when you settle in to celebrate Hanukkah, the first things that come to mind are usually very traditional. The smell of frying latkes, the glow of the menorah, maybe the spin of a dreidel. It's a real cultural touchstone.
It absolutely is. But if we stop the conversation right there, we'd miss this fascinating legal drama that's unfolding just beneath the surface.
Well, legal drama.
Yeah. The Festival of Lights is actually one of the most, well, unexpected case studies in the entire legal world.
Exactly. We've gone through the source material, and what we found is that looking at Hanukkah is this incredible, really dense shortcut into understanding four massive pillars of modern law:
It's true.
intellectual property and constitutional rights.
That's right. Our sources cover everything from how brand identity gets protected through trademarks to how stories and music are safeguarded by copyrights.
And even patents. I was surprised by that.
Yes, the surprisingly frequent invention patents for seasonal objects, and, maybe most critically, the really complex constitutional challenges around the public display of the menorah, that gets into the First Amendment.
So our mission for you today is pretty clear. We're going to distill all of this whole legal landscape, into a quick, targeted understanding. You're going to learn how culture, creativity, and law are constantly intertwining, and how the expressions of this 8-day celebration are, legally protected, but also challenged and preserved.
In the courts and in the marketplace.
Let's start right there, in the marketplace. The commercial battleground, trademarking the cheer.
It's intense. The visibility around Hanukkah in the marketplace is huge, and wherever you have commerce, you have this desperate need for brands to lock down a unique identity.
So companies are competing for sales and attention.
Fiercely.
Yep.
And so they try to own the slogans that they think capture the holiday spirit.
And the source material really highlights how creative and sometimes, frankly, how aggressive these companies get.
Oh, absolutely.
We see these specific phrases. They're trying to register everything from the cute and catchy, like, love you a lot, K,
Right.
to the more modern, party-centric slogan, something like, let's get lit.
And those examples, they really reveal the core tension in trademark law. For a trademark to even be protectable, it has to be distinctive.
Distinctive. What does that mean in legal terms?
Well, trademark law operates on a spectrum. At one end, you have generic terms, things like Festival of Lights or even just Happy Hanukkah.
Things anyone would say.
Exactly. They are inherently unprotectable because they just describe the celebration itself. They belong to everyone.
Okay, but the sources show that companies do file applications for phrases like Happy Hanukkah. So why would they bother spending the time and the money if the law says it's a non-starter?
That is a key insight for anyone interested in IP strategy. It's a tactic.
A tactic.
Yeah. Often, even if the registration fails because the phrase is too generic, the company establishes intent. It can also just work as a deterrent. A smaller competitor might get a cease and desist letter, and, lacking the resources to fight it, they'll just comply.
Even if the trademark wasn't legally defensible in the first place.
Exactly. It's a form of aggressive market signaling.
So protection really only kicks in when a phrase moves up that spectrum. Maybe it becomes suggestive or arbitrary.
Precisely. If a phrase is stylized in a unique way, or it's part of a very distinctive logo, that whole package might become protectable even if the words themselves are common. And the sources also remind us this protection extends to characters.
You're talking about characters like Hanukkah Harry from Saturday Night Live?
Yes, exactly. The trademark applications for him cover the use of the character's identity, his likeness, his name, on merchandise for entertainment services.
But I imagine this is a high conflict area.
It is. If a company tries to claim a slogan that the public thinks is already common, they inevitably face challenges over, the likelihood of confusion. Can that phrase really point to just one brand? It's an ongoing battle.
That feels like a natural transition. We've talked about the commercial side, but what about the creative heart of the holiday? The stories, the art? That shifts us from the competitive world of trademarks into the automatic safeguards of copyright.
What's so fascinating here is that while Hanukkah is built on centuries of tradition, the new expressions of that tradition get legal protection the moment they're created.
The moment they're fixed in a tangible form.
That's the key.
So if I write a new poem about the oil lasting 8 nights, it's instantly copyrighted.
It is.
But the underlying story of the Maccabees, or, say, the traditional melody of a song like Ma's Sir, that's all public domain, right?
That is the essential distinction. Copyright law protects the expression of an idea, not the idea itself.
Okay.
The idea of the Maccabee victory, the concept of lighting a menorah, those are free for everyone to build on. But your specific novel, your unique musical arrangement of that traditional song, or your modern graphic of a menorah, those specific expressions are protected.
Protected from what, exactly?
Unauthorized copying, distribution, or adaptation.
The source material mentions specific copyrighted works, like children's books and new music. So how does this law practically impact, say, an educator or a content creator who wants to share the holiday online?
It just means you have to do your due diligence.
Right.
If you're a content creator, you have to be thoughtful about where you're sourcing images or text. You can't just pull a modern image of a dreidel from a Google search and use it commercially.
Unless you check the license.
Unless you verify it's in the public domain or it's under a permissive license like Creative Commons. The law ensures creators can control their work, which, is crucial for fostering more creativity.
And that also brings up the thorny issue of enforcement.
Uh-huh.
For a small artist whose Hanukkah artwork gets copied by a huge corporation, defending that copyright, even though it's automatic, can be a financially crushing exercise.
Absolutely. The automatic nature of copyright is great in theory, but its value often relies on the creator's ability to actually defend it in court.
Which is a huge barrier.
A very costly barrier to entry. This is why many creators go the extra step to formally register their copyright with the U.S. Copyright Office. It gives them a much clearer paper trail for any legal battles.
Okay, so we've covered branding and creative works. Let's talk about the actual physical objects we use. This is the part that really shows innovation doesn't stop for tradition. I'm talking about patent law.
I love this part.
Is there really IP hidden inside a menorah or a dreidel?
There absolutely is. The sources show that inventors see opportunity everywhere, and the holiday is a perfect canvas for applying new tech to old forms.
So when we talk patents, we're talking about protection for inventions that are, novel and non-obvious?
Novel, non-obvious, and useful. That's the trifecta.
So what are some of the actual festive inventions that have been patented?
Well, the sources list patents for things like electric menorahs, and we're not talking about just the general idea of one.
No.
We're talking about very specific wiring mechanisms, new safety features. We also see patents for things like musical dreidels with specific tuning mechanisms or rotating toys that work in a new way.
I think the key distinction here, and it's one our audience always appreciates, is the difference between a utility patent and a design patent.
That distinction is paramount, especially for consumer goods. The type of patent determines what is being protected.
Right.
A utility patent protects how an item works. For that electric menorah, it might be a specific circuit board that ensures the lights turn on sequentially.
The function.
The function. A design patent, on the other hand, protects how an item looks.
Yeah.
Its ornamental design, its specific shape. For a novelty dreidel, the design patent makes sure no one can copy its unique visual aesthetic.
So these innovations, both utility and design, are really shining brightly during the holiday season.
They are.
That framework helps us understand that even a seemingly simple object can be a mix of centuries of tradition plus a layer of modern, legally protected engineering.
Okay, let's pivot entirely now. We've been deep in IP law, which is about private ownership and commerce. Our final segment shifts to public expression. We're moving into constitutional law and the First Amendment.
This is a pretty dramatic legal jump, right? We're going from securing ownership of a slogan to resolving fundamental questions about the separation of church and state.
In the public square. In the public square.
And the specific scenario that really drives these constitutional questions is the placement of large public menorah displays.
Right.
These really high visibility installations you see in city parks, public squares, sometimes right outside government buildings.
And when the government allows or places a religious symbol on public land, it immediately brings up the Establishment Clause of the First Amendment.
Which says the government can't establish or endorse a religion.
Exactly. So the core question for the courts becomes, does the government's action amount to an endorsement of Judaism?
I know the court has used some pretty complex tests to figure this out. For our audience, what's the current judicial framework for this?
Well, the courts often go back to frameworks like the Lemon Test or its more modern versions, but they mainly focus on what's called the endorsement test.
The endorsement test.
Yeah, and this test asks whether the government's action, so in this case, displaying the menorah, sends a message to people who aren't Jewish, that they're outsiders. Or, on the flip side, a message to Jewish people that they're insiders, that they're favored.
So it's not just about the object itself. It's about the message that object sends when the government puts it there.
Precisely.
So how do the courts reconcile this need for, general celebration with the rule against endorsement?
This is that delicate balance the sources get into. The courts have generally found that public menorahs can appear on government property, but context is everything.
Context.
The key finding is that the display has to be part of a broader seasonal or multicultural display. This is sometimes called, a bit humorously in legal circles, the reindeer rule.
The reindeer rule. I like that.
It just means if the religious symbol is placed next to enough secular symbols like a Christmas tree or Santa or just generic winter decorations, the overall message shifts.
It shifts from religious endorsement
To one of celebrating a general holiday season and cultural diversity, the message gets diluted.
That makes perfect sense. So if a city puts up only a huge menorah in front of City Hall, that's much more likely to be challenged and struck down.
Far more likely, yes. The municipality has to show its intent is to recognize the cultural nature of the holiday season, not to explicitly promote religious doctrine. And location matters too. Is it a private group's display in a public forum, or is it owned and placed by the government itself?
Wow. Okay, so from protecting a clever slogan like, let's get lit, all the way to intricate Supreme Court precedent on public religious expression. That is a truly comprehensive legal landscape tied to just one celebration.
It really is. And if we connect this all back to the bigger picture, Hanukkah gives us this powerful 8-day case study on how our modern legal systems are constantly shaping and preserving cultural expression.
So we have private law, like IP, that encourages new art and innovation.
And then you have public law, constitutional law, that regulates how that culture can be expressed in our shared spaces.
So what does this all mean for you, the listener? Well, the legal protections across all these domains, trademark, copyright, patent, and the First Amendment, are what ensure that the diverse expressions of the Festival of Lights continue to shine.
To shine brightly, creatively, and publicly for generations to come.
It shows that culture doesn't just survive on tradition alone.
No, it requires consistent legal maintenance to thrive in the modern world.
And that leads to a final, provocative thought for you to consider.
These legal frameworks, they essentially define the acceptable boundaries for the public expression of any major cultural celebration. So think about this. If a major holiday or cultural practice that you care about lacked these strong legal protections, if its symbols couldn't be trademarked, its new art couldn't be copyrighted, and its public displays were constantly challenged, how might its visibility, its very public presence, and its creative output be diminished or even stifled over time?